first one I will go ahead and call. It's Helen Jordan versus the Department of Health and Human Services. This is a 15-minute mini oral argument on the application. Mr. Bender, that means you can try and reserve time for rebuttal, but we will leave that to you, and you may begin whenever you are ready.
Thank you, Your Honor.
Sorry, pen situation. All set.
Good morning, Your Honors. I am pleased to court. I am Jacob Bender on behalf of Plaintiff Appellant Helen Jordan. If I may like to reserve 5 minutes for my rebuttal. It is important when looking at the facts of this case to not get too distracted by the role of opiates in it. The ramifications of this case extend well beyond opiates and extend to the foundations of the workers' compensation system itself. Michigan courts have consistently held for 100 years now that if you have wage loss and the original injury is a cause of the wage loss, that it's compensable. If there's traceable, if there's a connection. What the Court of Appeals did in Jordan was say that the original injury must be the cause of the wage loss. And the significance of this cannot be understated. So, for example, look at Staggs, a case that comes up over and over again in Jordan. In Staggs, in 1992, plaintiff won, and he fell at work. The original injury was not that bad, relatively speaking. The myelogram that he received as treatment for it significantly injured him, caused lasting disability. Under the Court of Appeals reasoning in Jordan, Staggs would have lost. And the reason why is that if you ask what the cause of the ongoing wage loss is, will be the myelogram, not the original injury. Well, the original injury was a cause, it's traceable as a connection. Under the reasoning in Jordan, it's not enough. Section 301 of the Workers' Compensation Act says that if you have a personal injury arising out of and in the course of employment, it is compensable. This Court of Appeals did in Jordan flies in the face of that, as well as a century of jurisprudence from this court. Thank you, and I welcome any questions.
Counsel, I do have a question. I'm wondering, when can a reviewing court, as part of its judicial review, consider a magistrate's factual findings, or are we only supposed to look at the appellate commission's findings?
So per Omian, which is a Court of Appeals decision, of course, it states that the factual review begins with the appellate commission. And so it's an unusual system in workers' compensation where it is really heavy factual emphasis on the findings of the appellate commission, not so much the original trial court, in this case, magistrate.
So it's your opinion we should just rest upon what the appellate commission found and not defer to the magistrate?
So that is where the case law points and has pointed for decades repeatedly. And it's also where the Michigan Constitution points as well, since the appellate commission is the final factual finder within the workers' compensation system.
Okay, thank you.
Are you referencing Mudell?
Yeah, Mudell, there's a number of cases on this, but Mudell is one of the...
Isn't Omer inconsistent with Mudell?
You mean Omian, sorry? I think I'm just making sure we're just doing the right case.
I'm sorry, I'm
You're saying Omian, O-M-I.
Omer, O-M-E-R versus Steel Technologies. 507 Mich 492.
So I apologize, I'm not the case. If it might be able to explain the conflict a little further, it might be a small briefing. I defer to you. I apologize.
Okay.
Counsel, I have a question about causation. And, you know, if we accepted this case that your client was disabled and there was a workplace injury, she was disabled, she was prescribed opiates. Opiates at the time were a reasonable treatment or accepted treatment at that time. But then we fast forward to the 2015, you know, the IME, I think by now we've discovered that maybe opiates aren't such a good idea. And there's questions are raised about, you know, whether she still has the injury that she had before, or whether now it's more degenerative. But my question has to do with her opiate addiction, and whether or not a person has an obligation to seek treatment at some point to deal with that. And taking it out of the addiction context, it seems to me an injured person does have a duty to seek reasonable treatment in order to, I guess, so to speak, mitigate their damages. You know, we've had case law going back, 100 years that says the claimant should discharge the primary duty owing to himself and society to make use of every available and reasonable means to make himself whole. We have other cases that suggest that a person has a duty to, if surgery is reasonable, for example, reasonable treatment, to have surgery. So for example, I mean, if the causation test is simply but for, what would happen if an employee broke their leg, his or her leg at work, and never sought treatment for it? Would the employer just have to pay for that employee's injury in perpetuity? Or does the employee have some obligation to seek reasonable treatment to try to improve their condition?
So I guess a couple of things. So first, it depends again on what we're talking about, because there's a lot of interlocking layers in the workers' comp. But at least in this context, it's not so much but for as it is traceable, connection. It gets kind of hazy, I guess.
Well, that's the question, causation. I mean, is it just but for? If it's but for and I break my leg at work and I never seek treatment, I could always say the injury was traceable to what happened at my workplace, right? The injury that occurred there where I broke my leg. But my damages that I suffer from that, could have been a lot less if I just would have had my leg set and listened to the doctor and stayed off it for a couple weeks. But instead I didn't do that, and now I've had to have my leg amputated. And does the employer have to pay for all that too?
I mean, personal responsibility goes to credibility, and credibility is always important. What I would want to note, though, in this case, that there's no suggestion in the record that Ms. Jordan was told to go to rehab and didn't. In fact, at one point she tried to go off her opiate medication. She testified at the hearing, and her doctors were frustrated with her and said, why are you doing this? Take the medication as prescribed.
Well, at the IME, I think at least one of them, that Dr. Mayer in 2016 recommended a medically supervised drug detoxification program to wean her from narcotic opioid dependence. Is that not a fact in the record?
So it's an independent medical exam, and at the beginning of those, they make it very clear they're not in a treatment relationship with the plaintiff, and that they're just kind of making suggestions. So I'm not aware of
Let's talk about it more broadly. I mean, if your client, I don't know how old she is, but say she has an opiate addiction 20 years from now, does she still recover workers' comp benefits, and that's traceable to her workplace injury? I mean, is there no time at which someone has an obligation to take steps to deal with their addiction?
So, again, addiction's one of those, I guess, frustrating topics because there's so much that plays into responsibility. Should they have done this? Should they have done that? One thing I want to caution, though, as we approach this case is that it extends well beyond opiates. And so while this court may take a position that, like the Court of Appeals did, Workers' Compensation Act, just legislative intent underlying it, cannot, does not envision lifelong opiate addiction as a compensable condition. If this court starts chopping away at what the Act allows for lifetime payment of, that what the Act allows for is if you are disabled, if you have an injury that's a work-related injury, you have wage loss as a result of it, as long as that's the case, you get payment forevermore, as long as you're able to prove it at every week of disability.
But here we have a secondary effect, right? The secondary effect is the treatment caused this person to become addicted to opiates. I'm willing to accept that. The treatment was reasonable at the time. The treatment is no longer reasonable, right? It's the doctors, I think the consensus, including her doctors, is that she should not be taking opiates. At this point, as a person who's addicted, I mean, is that a controversial assertion? We don't give drugs to someone who's addicted to the drugs, do we?
So I might be missing it, but I'm not aware of where any of her doctors said that she should stop taking them now. It's more of my recollection from the record excerpts that I looked at was they just kind of weren't sure what to do. I mean, she's been taking it for 20 years. At the time, that was what was done when testified. If you look at the records contemporaneously, they would say that this is really all we have for her. I'm not aware of any of her treaters saying that, oh my gosh, why is she not in rehab? Why is she still coming here?
So I guess just as a bottom line, I'm just trying to pin you down on, I mean, first of all, do you agree that a person outside of the addiction context has an obligation? I think the case is called Krasinovich, 192 Mich. 6-87, has a duty to take steps to heal, to receive reasonable treatment when they're injured at work? Do you agree with that proposition?
A person should always seek treatment for an injury, certainly.
All right. And so what happens when a person has an addiction problem? Do they have an obligation to seek treatment to help deal with the addiction?
I think they should do whatever their doctors told them to do, because that's who's going to know best. So
if her doctors tell her or keep prescribing her opiates, but if the IME doctor says, that's a bad idea for you, you're addicted to opiates, this is not a good path that you're on, and here's what you need to do about it, she has the right to listen to her doctors and not listen to, I guess at that point, wouldn't the court have to determine which doctors are giving the correct medical advice?
So I think one thing to note here, I guess, is that was not what the magistrate really engaged in at all. So I see where you're going with this question. I certainly understand it. But at least in the context of this case, I don't know that it reaches that far because the magistrate didn't even touch on that question in her factual findings.
And the magistrate found that the disability was from the opiate addiction, not from the original injury, right?
Correct. But as far as whether any doctor, which to my knowledge none did, said, get in rehab, what's wrong with you? Why are you coming here?
I just don't see how this court can avoid the question of whether that disability, the opiate addiction disability, resulted from the workplace injury under the statute, the causation question. It's the same, I think the same traceability question that's in the Staggs case.
So
And it's the basic question under the statute that we're gonna have to ask is not whether her opiate addiction when it first happened 20 years ago was resulted from, her workplace injury, but whether her continuing opiate addiction 20 years later should be considered as something that results from her workplace injury.
So I think that you're touching on what actually, a few things I highlighted here. The Court of Appeals said it's a properly framed question whether Jordan's opioid use in 2015, i.e. at the time treatment at the time benefits were halted, was in response or traceable to 1995 work-related injury, but only to the extent the effects of that injury still existed in 2015, which is still being prescribed opioids. So again, what that comes back to, and that the Court of Appeals reasoning there ignores, is the addictive nature of opiates. She's not physically dependent on opiates. None of her doctors have suggested weaning her off of them, stopping them cold turkey. She's simply on them.
Counsel, isn't it fair to say that I think what this case comes down to from a human perspective is that anyone who's been in a catastrophic injury, it's the hardest thing about being in a catastrophic injury is you go from being a healthy person, you go from being in this situation, you go from being in perfect physical condition, and that once you have a catastrophic injury, there's a linear effect that causes all these other things to happen. Isn't that really the essence of it? We can get into the but for and all the different elements, but the real challenge of this is that you take a person who's perfectly healthy, who lives a vibrant, active, energetic life. This is the catapult that basically allows for all of these difficulties and challenges to arise. Isn't that the essence of what is happening here?
Certainly. So Ms. Jordan was a healthy nurse in her 50s, went to work one day, wasn't expecting anything, and a 300-pound inmate hit her so hard she literally flew out of her shoes.
Right.
So yeah, that was certainly not something she was expecting, and it's changed her life, 20 years later, 30 years almost now.
Would you like to reserve 1 minute?
Yes, certainly, sure. Thank you.
Absolutely.
Good morning, Madam Chief Justice, and may it please the court. Ryan Galen on behalf of the Michigan Department of Health and Human Services, the appellee. Alongside with me today is Assistant Attorney General Jason Hawkins sitting at council table. The Court of Appeals decision before you is far narrower than what appellant argues. They seek error correction, but there is no error to be corrected. Though the facts of this case are interesting, the legal issues involved are very typical of a workers' compensation case, and the Court of Appeals decision will not do anything to change workers' compensation jurisprudence. Upholding the Court of Appeals decision will maintain the status quo. I say that because the Court of Appeals did not reverse the holding in Staggs versus Genesee County, nor did the Court of Appeals limit the applicability of Staggs to one-time medical treatment. And the traceability test set forth in Staggs remains even after the Court of Appeals decision. To be clear, the Court of Appeals in this case allows for continuing medical treatment to be a compensable disability if it is reasonable, necessary, and traceable to a work injury. However, as a threshold matter, there must be a work injury present to trace the medical treatment to. And that is the problem in this case with these facts. The magistrate conclusively determined that as of February of 2015, a work injury was no longer present to trace the appellant's opioid treatment to. At that time, the only conditions to trace such treatment to was degenerative arthritis, age-related, not work-related, and pain of an unknown origin. Thus, at that time, there was no injury to trace the medical treatment to, and therefore, benefits were properly denied prospectively. And for those reasons, we ask this honorable court to deny plaintiff's application for leave to appeal and affirm the Court of Appeals.
You agree the Court of Appeals essentially found that the Workers' Comp Appellate Commission failed to give proper deference to the magistrate?
Yes, I do, and I also believe the Workers' Compensation Appellate Commission committed legal error. I do believe they looked at the case under an improper legal framework. I think they assumed there was a continuing injury when the magistrate clearly found there was not. They did not address the magistrate's credibility findings with the doctors. They did not disturb those findings. And again, as the Court of Appeals pointed out, the traceability test needed to be performed in 2015 when benefits were at issue, not back in 1995 as the commission found.
Are you familiar with the Omer decision?
I am familiar with the Omer decision.
Is that in tension with the Mudell decision?
I think,
Help me reconcile the two.
well, I think Mudell requires that the magistrate have competent material and substantial evidence to support its decision. And I think, not overly familiar with the facts of Omer, but I do believe that it stands for a similar proposition, that as long as the magistrate has supported that position, that the magistrate's findings should be accepted. And I don't think that's what happened here, if that answers your question. And I'm not sure I did.
I guess, is there tension between Omer and Mudell, and do we have to fix that? You came up and you said there's nothing jurisprudentially significant here. I'm looking at two cases from our court, and I'm having a hard time reconciling them. And if they need to be reconciled, then there is something jurisprudentially significant to be done here.
I don't believe they need to be reconciled, Your Honor.
Maybe I'm missing something, but I'm not sure where I see the conflict in the findings of fact by the magistrate in the, do you say MCAC? Is that a thing we say?
It used to be, now it's the Workers' Disability Compensation Appellate Commission.
So, what you just said, it seems to me like the magistrate found facts related to the 1995 injury, pain from the 1995 injury, and then the commission found facts related to the opioid addiction, which is its own disability. Do you disagree? And therefore, they don't seem mutually exclusive or in tension to me at all.
I disagree from the standpoint that the opioid addiction was not pled independently. It was not pled in this case. The issue before the magistrate was whether Ms. Jordan's back injury continued to support a claim for benefits.
So if they had pled that her opioid addiction entitles her to benefits, you wouldn't be here. You would say absolutely she's entitled to benefits. The problem here is bad pleading. She should be suing her lawyer.
No,
Not-
no, I'm not suggesting that at all.
Well,
What I am suggesting is that this was a sequelae situation. That's where the Staggs decision came into play. And because it was a situation involving post-injury treatment, a sequelae, that's where the traceability test could come into play.
yep,
And, but importantly here, and I think this is important to note, the magistrate found there was not a continuing injury as of 2015. And therefore, as with any workers' compensation case, the case stops right there because you can't prove a disability. You can't prove a compensable workers' compensation claim without a work injury.
But let me just get you on record. So if she had pled that she wanted benefits based on her opioid addiction, which stemmed from her workplace injury, you would not have contested that claim.
I don't believe, as the magistrate found, that the opioid addiction.
I'm
as
not
a-
asking what the magistrate, you get to decide. If she had
Oh.
said, if she had said, I want disability benefits because I am now addicted to opioids, because that was exactly what was prescribed to me because of a workplace injury. She's not someone who used opioids before that, right? She's one of like a tragic generation of people who became addicted to opioids because that's what their doctors told them to do to treat their pain. You, the department, would have said, yep, you're entitled to benefits because you pled this correctly. Is that
Okay.
right?
I'm not trying to evade your question, but I do think it would depend on what the testimony was to that issue directly. There would be medical testimony, as there was here, from Dr. Bellin, Dr. Mendelsohn, Dr. Audette. If they had all said that the opioid treatment,
I'm going to keep asking it, so you can keep answering a different question, or you could just answer my question. And
think-
I politely, I really, really just want you to, like, because you don't have to contest it, right? You don't have to go to a hearing. You could have just said, you're right. There is a tragic generation of people for whom we're going to be on the hook for paying benefits because they have this disability that is no fault of their own, that stems from their original injury.
if the plaintiff had come to us and said,
Yeah,
I'm on opioids, I'm addicted to them because of the work injury, I think this claim would have been picked up, yes.
thank you. I
So
appreciate that.
let's get to my issue then, I guess. You don't believe that people have any obligation to seek treatment for their addiction?
No, I do. The Workers' Compensation Act requires employers to provide rehabilitation to injured workers. That's a central tenet of the Workers' Compensation Act. And the employee has an obligation to comply with such rehabilitation efforts.
Fair to say that's not how this case was litigated, that's what you're saying?
Yes.
So this issue of what the chief is asking you to agree to, and the issue I'm raising is not really where this case centered. It was more on whether the injury continued.
That is correct.
Into 2015.
Yes, and that is correct, and that's exactly what the magistrate put, I believe, in the first sentence of her analysis. The question was whether the 1995 back injury continued and was still disabling. That is how the magistrate viewed
But
the
counsel,
case.
how is that, how do we reconcile, we know a botched surgery after a workers' comp action is covered. We know that the effects of that botched surgery for the rest of the person's life, they get coverage. How is this any different? It's like a botched treatment plan.
Because this was continuing treatment. And I see exactly what you're saying when it comes to a botched surgery. And again, these cases are very factually specific. So in the hypothetical that you had just presented, I think the evidence would show there was a direct traceable link between that surgery and the sequelae, the effects of it, because there would be no break in the chain, so to speak. In this case, it was a continuing process. It went on and on and on for obviously over 20 years, and because of that, traceability has to keep getting measured on a continuing basis, which is consistent with the Workers' Compensation Act, which allows for change of conditions. Injuries are always looked at as a continuing basis. Sometimes they improve, and the carrier can reduce or terminate benefits. Sometimes they get worse, and the plaintiff can get extra benefits. But it does have to be looked at as on a continuing basis, and in the hypothetical that you presented, I don't think it was a continuing situation. I think the traceability would have been very easy to show in a situation such as that.
How do we reconcile that states all over the country, including our own, are involved in lawsuits about opioids and how they were prescribed, and the notion that, to the Chief Justice's point, that we have a generation that became addicted to prescription medicine that was prescribed by their doctors? How do we reconcile that? We've got our own Attorney General settling these cases.
Well, obviously, it's a horrible situation, and Ms. Jordan's in a really tough spot. I don't deny that. I readily acknowledge that. However, we also have to take into consideration the elements of proving a workers' compensation claim. So obviously, we don't want anyone addicted to opioids. That's the worst case possibility. And you see it in this case. All doctors testified this was not appropriate. The continuation of this was not appropriate. And I don't think the Workers' Comp Act would contemplate that inappropriate treatment should be performed in conjunction with the workers' compensation claim.
Thank you.
And again, I would hit on the factually specific nature of these claims. There's a lot of different hypotheticals that could be presented as to whether something is traceable, whether it's not traceable, but the facts are the facts. And in this case, the plaintiff did have the opportunity to prove traceability. There was medical testimony taken, it was presented to the magistrate, and it is within the magistrate's purview to make those credibility determinations, and that is exactly what happened here. So I think that is an important point to cover. If there's any other questions, I'm happy to answer them.
What should the plaintiff have done differently?
What should the plaintiff done differently? I think the plaintiff, I'm not the plaintiff's lawyer, obviously, so.
But I mean, like, what is it they did wrong? What should they have done differently?
I think that it would have been, if the plaintiff was able to get testimony that the back injury continued, credible testimony, through 2015, the opioids were in response to that injury in 2015, I think the plaintiff's case would have been better. That's as far as as far as I would say. But again, it was hard because the doctors all testified that the opioid treatments were not appropriate. So I think that was an obstacle, for the plaintiff in this case. But if there was different medical testimony, it could have went a different way. And again, if there's any other questions, I'm happy to answer them. Otherwise, I would just state, and thank you very much for your time this morning, that the state once again requests this honorable court deny plaintiff's application for leave to appeal and affirm the Court of Appeals decision. Thank you very much.
Thank you, counsel. Thank you very much. You have 1 minute.
I just want to touch on a couple of brief things. First, part of what makes this case unusual is the addictive nature of opiates. So since they were prescribed back in 95, even though there's medical testimony that arthritis is now the issue or some unknown pain.
Counsel, if you could respond to Brother's counsel about what should have been done differently as it pertains to the medical testimony.
I would concur with his assessment as far as medical testimony. It's a problem when the magistrate made her factual findings, which were displaced by the appellate commission. Had she found differently, this would have been a non-issue. Which actually, I want to touch on the appellate commission. When they displace factual findings by a magistrate, the standard of review is it can only be disturbed if they misapprehended or grossly misapplied the substantial evidence standard. That did not happen in this case. So with that, I take my time. All right, thank you.
Thank you very much. The case will be submitted.